everybody. This is part 3 of our workers' comp subrogation series. We're calling it the War Story Successes and Failures. We discussed in part 1, if you haven't heard it, we discussed generally what is workers' comp subrogation and why are we a necessary evil, right? I mean, workers' comp is a necessary evil because that's our world. You get hurt on the job, you get workers' comp, there's a lien. We want to get that benefits that you're getting back, and that's where we come in. And we talked about working with Claimant's Counsel. Why do we want to do that? We want to do that because we want to get the lien back. We want to work with them to help forward a third-party case. So we talked about what is workers' comp and how it fits in. We talked about the process. We talked about who's part of it. We talked about the investigation, which is really where we come in to our own, really where we can be useful, because workers' comp professionals, one of the first people to know when an accident happens. We told you how to investigate. We told you the things you should be looking for. And we talked about taking that whole investigation and helping it to further a third-party case. Now we're going to talk about investigations done. We're in litigation, right? We've gotten the work comp claim. We're investigating it. Now what? Well, we can make a demand on who we think is at fault, and they're usually going to go, pound sand. Or the best, I love this, and tell me this doesn't happen to you all the time, Mike. We get a loss, and our client says, well, the statute runs in a couple of weeks. We go, why did you wait? Well, it was a really good loss, and the adverse adjuster, we made a demand, and they said, we're evaluating it. And they keep on evaluating it. They're going to keep on evaluating it right past that statute. And then they're going to say, too bad.
When I was growing up, maybe meant no. And I swear, I think every insurance adjuster grew up the same way.
But then you have the cases, which is really the bulk of what we're talking about, where there's a third-party attorney, right? The injured worker, the claimant, has gotten an attorney who's pursuing a case. And they're in a position. They want to file a lawsuit. If they can't settle it in enough time, they're going to file a lawsuit. And hopefully, we have developed a rapport with them. Hopefully, we have given them the results of a great investigation. We've given them a great expert to work with. So now what, right? Now we're in litigation. So one of the ways that we like to get into some kind of agreement with counsel is called a ladder agreement, okay? The ladder agreement is kind of what it sounds like. If you settle for X, you will agree to repay Y of the lien. If you get $50,000 more, you'll pay X on the lien. If you get $100,000 more, and so on and so forth. Now, why would we do that? In what state would we do that, Mike?
Well, there's a ton of advantages, but the biggest advantages are in states where subrogation is more difficult to begin with. A state like Georgia, where made whole doctrine could theoretically allow for a situation where we've assisted the injured worker, they've gotten counsel, they've made a great recovery. Now it comes time to pay back the lien. And as you pointed out in our first session, it is very difficult to convince a judge that a person who's lost both of their legs has been made whole. And we would have to prove that before getting the lien back. However, if we've already reached an agreement with counsel in which they've agreed that for every $100,000 that they receive on the claim, that they will pay a certain amount towards the lien, then we are standing in front of that very same judge as a united front. And in some cases, the recovery may not have been possible without that ladder agreement. And that's really what I think we focus on when we approach third-party counsel in those circumstances. Brett, I know you've been doing this a long time. Where do you find the most success when dealing with ladder agreements, as far as what kind of attorney you may be looking for that?
Well, it's interesting. What kind of attorney is going to be wanting? Well, you got to look at who is the third-party counsel. Sometimes third-party counsel is the injured worker's brother's, cousin's, son, sister's, father, who dabbled in personal injury as a youth and now does mostly estate work.
Aren't those fun?
Yeah. I mean, that guy is going to want a lot more than a ladder agreement. He's probably going to want to partner with us, and we'll talk about that next. But that's an unsophisticated attorney. They might be very well sophisticated in estate law, but not in product liability law. Then you've got, and it doesn't matter whether you're in urban locations or suburban locations or rural locations, you could have the best products liability attorney in the middle of nowhere. And that guy might not need anything. He might say, I don't want to ladder with you. I don't want to partner with you. I know exactly how to do my job. I know exactly what the law says, and go pound sand.
But even that guy, if you offer to pay some of his costs, might eventually see the light and be willing to ladder with you.
Exactly. Depending on the facts of the case, sometimes that guy might want your help. It might not be the best case. We might have access to information that just would really help him, and he might say, "You know what? It's a quid pro quo. I know that based on this ladder agreement, that if I get X amount of money, I'm going to pay back Y. I know that, and I know that if I make $500,000, I'm going to pay the whole lien back, or whatever. It's something that you can bargain for, that they're aware of, that his client knows going in. So, laddering agreement, as we'll talk about, laddering agreement has a lot of benefits, but it's not my favorite. But I'll give you a great example, Mike, of a laddering agreement that we did. It was a case that we got the case 60 days before the statute ran. All right, the facts of loss were pretty simple. It was a California accident with Arizona benefits. Now, Arizona is a pretty good state for workers' comp subro. California is not too bad either, but it has its quirks. And the reason why I say that is in California and Arizona, basically, we're supposed to get first money. But what ends up happening is in California, there is a reduction for employer negligence. It's a case, Witt v. Jackson. So if your employer is found to be negligent because maybe they didn't train your guy correctly, maybe they actually did something negligent, or for a variety of other reasons, that will reduce the lien. Arizona has the same thing. The lien can be reduced for employer negligence. However, the big difference is in California, the plaintiff can settle around you. In Arizona, employer negligence has to be proven by a jury verdict. So you could say all up and down to you, get blue, oh, the employer is negligent, you're going to have to reduce your lien. And we think, maybe try the case. California, you can't. So we did a choice of law analysis, but the fact of the matter is this was going to be a California case. And anyway, we got the case, and it was a guy went to pick up a load of lumber, okay? And at the lumber yard, they put on a tarp, but they didn't attach it properly. And before the guy left the yard, he got out of his truck to go sign something, and the tarp fell on his head. And the tarp weighed a couple 100 pounds, and it gave him traumatic brain injuries. Now, it turns out that he had his own workers' comp counsel in Arizona who did some kind of investigation, didn't think it was a good case. We got the case, again, about 60 days before the statute. We spoke to the employer. We spoke to a couple witnesses in the accident. And we found out this case actually looks like it might be pretty good. Why? Well, it turns out that the responsibility to load, the responsibility to make sure that tarp was secure, all that stuff was on the defendant, where the trucker was getting his flatbed loaded. Because of that, we thought, hey, this is good. So we ended up getting into a ladder agreement with this attorney who went and pursued a California case, and he went and made a fantastic recovery. We got 100% lien reimbursement. Now that sounds great. Why isn't it my favorite? And the reason why is because with a ladder agreement, we're not as involved as I'd like to be. We were able to and here we needed the participation of the injured worker. We needed his testimony. We needed his help because without him, he was the star, and he had an attorney who wasn't going to do anything. And we could file a lien-only action, but then we don't have the cooperation of the worker. So here we had a guy who was willing to do a ladder agreement, but again, we're then monitoring. I mean, we got to read deposition transcripts. We got to help plaintiff's counsel behind the scenes as far as we helped them retain counsel. We helped We helped them retain experts. We helped discuss strategy. We helped them with deposition preparation. We helped with access to the employer, things of that nature. But we weren't driving the bus. And sometimes I like to be the one who's doing the depositions. I like to be the one who is calling all the shots, especially if I think my partnering attorney might not be the best person to do it. Sometimes they are the best person. But anyway, that was a fantastic result. But where I do really like is what I think is the best for everybody is partnering agreement. Now, in a partnering agreement, it allows us to be involved at all stages, okay? Under the terms of a partnering agreement, depending on what we agree, I might be counsel of record for the plaintiff along with the plaintiff's counsel directly. I might be that way. I'm litigating everything. I have an active say in what I believe they should be doing. I have an active say in retaining experts and preparing for depositions and doing everything. Now, I know what you're going to say, but say it anyway. Common interest.
The common interest doctrine is an
I had to slide
exception
him the paper over.
to the general rule that disclosure of the communication to a third party destroys the privilege, which basically means that in some limited circumstances, you can claim that your communications with people or entities that had the same interest as your client should fall under the attorney-client privilege. It gives you a little bit more elbow room when you're trying to do your investigation and you're trying to work closely with another attorney or another party. But this is a little different in each state. So please research it before you make any assumptions here. And that's on a caveat to the attorneys listening, all two of them. But it is an important snag and not a place you want to find out you've made a mistake after the fact.
So I want to talk about a great example of the using the common interest doctrine to your advantage. There was I recently had a North Carolina accident. North Carolina is a very difficult jurisdiction. It is a 1% contributory negligence state, which means, Kate, if you're 1% at fault, you lose. Versus California, where you could be 99% at fault and you still get 1%. So if you won $100, you were 99% at fault, you get $1. Versus North Carolina, where you could win $1 billion and be 1% at fault and get nothing. Not very fair. So that's for the plaintiff if they're 1%. Now, if the employer is found to be 1%, they could have their lien waived. So that's not fair either. So in North Carolina, there were these two gentlemen. They were cleaning at a car dealership. They were evening custodians. And they were using some kind of industrial chemical cleaner, brake wash, for some reason. And they used a buffer and it caused an explosion. And these guys got a lot of bad burn injuries. The defense here, it was scorched earth, right? There was a third-party attorney who came in, represented the workers, and interestingly enough, it was an attorney that I had worked with before in other cases, so he knew me and couldn't wait to partner with me because he trusted me because we helped him achieve great recoveries before. But it was a scorched earth thing where their defense was, hey, you are the custodial engineer, and you should read the MSDS sheets on what you use. You were in the best position to know what's happening. And the plaintiff was saying, well, I've been doing this for 30 years. I've never had an explosion. You guys gave me a cleaning material and said, use this. And I'm going to listen to what you tell me because you're the customer. And that's what I'm going to do. You're the customer is always right. And we had access, obviously, to the employer. And we discussed with plaintiff's counsel. He was able to speak with the employer directly, not under oath, but in order to prep for depositions. We were able to share information. We were able to share documents, discuss theories together. And all that was under the common interest doctrine because we both did have a common interest. What was that common interest? They wanted to make a recovery. We wanted them to make a recovery so we could get our lien repaid. And it was all tied in on their success.
Now, that sort of brings us to the other side of that very same coin. If you're not working with the injured worker's attorney and you're not working with the injured worker, what do you do? If you're, for instance, let's say a state like California where you're allowed to pursue a lien only, where you don't have critical information of the injured worker's testimony and you don't have the availability to have an attorney be able to speak to them that they trust to give you the rawest information possible. Now, it's still possible to go it alone, but a result like that is much less common in those circumstances.
That's true. It is much less possible. And again, in California, if you're just going to intervene, you're going to represent the carrier. You got to be willing to fight it out. If the plaintiff's attorney wants to settle around you and he doesn't want any help from you, and he does settle around you, you have to be ready to litigate it. Now, here, by going back to this North Carolina, we had to defend both. We were able to, first of all, we partnered with plaintiff's counsel, and I was able to enter on behalf of the non-party employer to defend them against allegations of negligence so the lien wouldn't be waived, but also to help the plaintiff boost the plaintiff's claim. We also helped. It was expensive to litigate. We helped fund the litigation. We helped select experts. There was an origin and cause expert. There was a mechanical engineer. There were medical experts. There were vocational experts, economists, a whole bunch of things. So because we partnered with counsel, we were able to work together, and the result was a fantastic lien recovery. And we were able to go to that 9710.2J hearing, that equitable distribution hearing, which is similar to made whole, but it's not made whole, but it's not too much different. And we walked hand in hand to be able to get the claim and settle it. And that's how we helped Counsel help me help you achieve the best lien recovery. And it's really about making ourselves indispensable, becoming the best we can be to help the plaintiff to get that $1 billion so we can get our lien.
In
Okay.
presenting that united front, you increase the total recovery, you increase your client's recovery, and everybody goes home happy.
Now, thank you very much for everyone who's made it this far, who's listened to all three. I hope you've learned something. If you have any questions, feel free to reach out to myself or Mike anytime. We look forward to speaking with you. I hope you've enjoyed it, and good night. Thank you.
Be sure to check out our upcoming episodes. You can find past episodes of the podcast and relevant case updates on the Subrogation Strategist blog, all available at whiteandwilliams.com.